This video is made for educational purposes only and cannot be taken as legal advice.
In this video we are going to take a look at a High Court ruling that upholds the right to free speech and freedom of expression covered under the Human Rights Act. 1. This is an appeal against conviction by Kate Scotter, aged 39. On the 7th of February 2020, after a trial in the Magistrates' Court at St. Albans, she was convicted by District Judge Margaret Dodd of one offence of improper use of a public communications network. Ms. Scotter now appeals by way of case stated. 2. Ms. Scotter's case that the prosecution was an abuse of process, the charge was duplicitous, and partly out of time. Secondly, there are matters of substantive law. Ms. Scotter says that those acts that were within time could not be described as persistent, and, in any event, on a proper interpretation and application of Section 127(2)(c), the facts alleged disclosed no case to answer. So and it was wrong in law to convict her on that factual basis. In this regard she relies, among other things, on human rights arguments founded on the right to freedom of expression. The factual background. The prosecution stemmed from complaints by Stephanie Hayden about messages posted on social media. Ms. Hayden is a trans woman, with a public profile as an activist and advocate on transgender rights.
It is common ground that she is to an extent a public figure.
Ms. Scotter describes herself as a radical feminist, and takes views that oppose some of those advocated by Ms. Hayden. The facts of the matter have not been as easy to identify as they should have been. This is a result of several factors: the fact that the prosecution did not obtain all the contextual material for the offending messages, the somewhat disorderly way in which the case for the prosecution was presented at trial, the diffuse nature of the arguments for the appellant, the limited fact-finding in the judgment of the district judge, and the unorthodox nature of the case stated. The formal information that was laid before the Magistrates' Court is not before us, nor is the summons, nor were the essential facts relied on set out in the prosecution opening.
Nor has anyone prepared a basic chronology of the key facts.
An argumentative chronology was prepared by counsel for the purpose of the case stated and skeleton argument, but this was not adopted nor commented upon by the district judge. It unhelpfully weaves together facts which were, and those which are not clearly found by the district judge, together with comment and submission, and contains some errors and omissions. To a substantial extent, it has been necessary to reconstruct events, using the papers before us.
I am confident, however, that the following facts were established before the district judge, or are agreed, or clear beyond dispute. The acts of using a public telecommunications network that were relied on by the prosecution at trial consisted of 17 messages on social media, 16 tweets which Ms. Scotter admitted making, and one message on Mumsnet from a username Burnt Marshmallow, which she could not recall. The nature of Twitter and Mumsnet are by now well known. The former is a social media platform for microblogging, the characteristics and workings of which are set out in Chambers v. Director of Public Prosecutions, 2012. 7 of the messages relied on by the prosecution were posted in 2018, the 2018 messages. 1. On the 9th of September 2018, Ms. Hayden, using her Twitter handle @FlyingLawyer73, posted a tweet which started, "You know, not so long ago people like you had no civil rights. Yet you." Ms. Scotter, using her Twitter handle of @BustedWench, tweeted in response as follows. Tweet 1. "Let's hope they take a serious stance on your racism, evidently." She took Ms. Hayden's tweet to be addressed to a black person. 2. On the 12th of September 2018, Ms. Hayden issued a Part 8 claim in the County Court at Leeds under Claim No. E73 LS068, alleging harassment by 4 defendants, of whom Ms. Scotter was one. Ms. Hayden made a witness statement, but did not formally serve the claim form or the witness statement on Ms. Scotter. 3. A notice of discontinuance was filed with the County Court and served on the 28th of September 2018. Ms. Hayden posted the settlement agreement online in some form. The tweets.
On 1 or the 2nd of October 2018, Ms. Scotter tweeted a copy of the notice of discontinuance, tagging in Ms. Hayden. Tweet 2. To do this, Ms. Scotter used a newly created Twitter account with the handle @AliceHampton. By this time, Ms. Scotter had blocked Ms. Hayden from her @BustedWench account. On the 2nd of November 2018, Ms. Scotter tweeted on the @BustedWench account as follows: Tweet 3, by way of a reply to tweets by others. Sadly, I'm not allowed to discuss as per his bullying contract. Good will out though, and he will be fucked in a few years' time. On the 6th of November 2018, Ms. Scotter took, and posted on her @BustedWench account, a screenshot of a post by Ms. Hayden, with the message: Tweet 4. This person is not a racist, xenophobic LARPing lawyer, trans woman. This person is a crook using the trans facade to ensure they aren't caught. A pig in a wig. On the 9th of November 2018, Ms. Scotter used her @BustedWench account to tweet a post by Ms. Hayden critical of Mumsnet with the statement: Tweet 5. He is a very sick individual, I've evidence of that. On the 9th of November 2018, Ms. Scotter posted a further tweet on her @Hampson Alice account, in which she tagged Ms. Hayden. Ms. Hayden had tweeted about an intersex advocate, critical of anonymous freak trolls obsessing and speculating over her every move, and suggesting that something must have upset them. Ms. Scotter's tweet said, "Christ, surprised your memory has held up given you're claiming PIP for it." On a date unknown on or before the 11th of November 2018, a message was left on Mumsnet from an account named Burnt Marshmallow as follows: Message 7. I have many leads on the claimant there on PIP for memory loss. On the 11th of November 2018, Ms. Hayden made a report to West Yorkshire Police, alleging harassment and malicious communication by Ms. Scotter. She made a statement. 4. On the 1st of December 2018, at the instigation of the West Yorkshire Police, PC Kitchen of the Hertfordshire Police arrested Ms. Scotter on suspicion of harassment and malicious communication. Ms. Scotter was interviewed. She admitted the 2 Twitter accounts were hers, and that she had posted the 6 tweets. She did not accept posting message 7. She denied committing any offense. At the time of arrest, the officer seized Ms. Scotter's Samsung mobile phone and her Asus laptop. The police, apparently expecting a guilty plea, decided, later on, that downloading data from the phone or computer would be disproportionate and unnecessary. 5. On the 1st of December 2018, Ms. Hayden posted 5 tweets highlighting the fact of the arrest, though not Ms. Scotter's name, describing this as positive news regarding the #harassment I have received in recent weeks.
And as sending a clear signal that #transphobia and #harassment will not be tolerated.
6. In early December 2018, Ms. Hayden issued proceedings against Ms. Scotter in the High Court under Action Number QB2018000294. On the 18th of December 2018, Ms. Hayden appeared before Jason Coppell QC, sitting as a deputy judge of the Queen's Bench Division, and obtained an interim injunction prohibiting Ms. Scotter until trial or further order from publishing any personal information relating to Ms. Hayden on any social media platform, as well as more specifically, misgendering her on any social media platform. Publishing anything linking her current female identity to her former male identity, and anything stating or implying that she is a racist or has published anything racist on any form of social media. Ms. Scotter was neither present nor represented at the hearing when this order was made. 7. Later the same day, Ms. Hayden posted 4 tweets containing news of the injunction, giving a summary, and tweeted a photo of the order, but with Ms. Scotter's name redacted, asking others to retweet.
8. The public record shows that the civil proceedings against Ms. Scotter remain alive, but stayed pending the outcome of these proceedings.
Questions for this court. The questions referred for the opinion of this court are as follows. 1. Should this case have been stayed as an abuse of process on any of the argued grounds in the updated skeleton argument served 5 February 2020? 2. Should the case have been stayed as an abuse in accordance with DPP vs. ARA 2002? 3. Was the charge duplicitous and therefore should the court have required the prosecution to split the charge and then ruled that anything pre-27.2.19 was out of time? In reality on the evidence pre-9/11.18, or stayed any prosecution of a charge with an end date pre-27.2.19 as an abuse of the court's process. 4. Did the judge correctly interpret and apply the law in light of the interpretation that would need to be given in light of Article 10 ECHR and S3 Human Rights Act 1998? B. Should the case have been stopped on a submission of no case? 5. Was it proper in law to convict on the facts as alleged? 7 tweets, only 3 of them directly notified to the complainant September to November 2018, and 9 tweets on the 1st of March 2019, none of which were said to be objectionable until the complainant learnt by investigation that they came from an account operated by the defendant. I.e., was there evidence on which the court could come to its decision? 9. In my judgment, the prosecution and the judge had insufficient regard to the legal context, which is all important. 10. In 1988, Parliament enacted the Malicious Communications Act.
By Section 1(1), as amended in 2001, a person is guilty of an offense if he
sends to another person a letter, electronic communication or article of any description which conveys a message which is indecent or grossly offensive, a threat, or information which is false and known or believed to be false by the sender. 11. As Ms. Wilson reminded us, where the claimant is, by choice, a public figure that should influence any assessment of whether particular conduct amounts to harassment of that individual, such a person has, inevitably and knowingly, laid themselves open to close scrutiny of their every word and deed, and others can expect them to be more robust and tolerant accordingly. Peruba vs. Russia, 2009, and domestically.
Trimingham v. Associated Newspapers Limited, 2012.
12. In a case of alleged harassment by publication, the court, in order to protect the right to freedom of speech, should take account of the extent to which the coverage complained of is repetitious and taunting, as opposed to being new, and prompted by some fresh newsworthy event. The imposition of liability in respect of coverage that falls in the latter category will be harder to justify. 13. Ms. Hayden reported Ms. Scotter for harassment and malicious communication. As a result, Ms. Scotter was arrested and interviewed on suspicion of having committed offences contrary to the Acts of 1988 and 1997. Ms. Hayden evidently relied on the statutory tort of harassment, among other causes of action, for her injunction application in December 2018. 14. The prosecution did not charge Ms. Scotter with malicious communication or harassment, but with an offence contrary to Section 127(2) of the 2003 Act, which charge they then amended. They presented that charge to the judge as if it were a lesser version of harassment with a less demanding threshold, a kind of harassment light, in which it was enough to prove an intent to cause offence of at least one, the kinds referred to in Section 127(2)(c). That, in my judgment, is also how the judge treated the matter. I am satisfied that this was wrong in law. In addition, although the convention was mentioned by the prosecution and the judge, the approach of both, and the judge's analysis, were legally flawed and inadequate. 15. It is clear, in my judgment, that these provisions were not intended by Parliament to criminalize forms of expression, the content of which is no worse than annoying or inconvenient in nature, or such as to cause anxiety for which there is no need. First, the crime is only committed by conduct that is, for the purpose of causing annoyance, inconvenience, or anxiety. I add the emphasis to highlight the contrast with Section 1 of the Malicious Communications Act, above. Secondly, it can only be committed by the persistent use of a public telecommunications network. That encompasses the use of Twitter, see above, but I do not consider that the mischief aimed at by Parliament when it passed Section 127 of the 2003 Act was as broad as causing offence online. 16. The legislative history of Section 127 was traced by Lord Bingham in Director of Public Prosecutions v. Collins. Lord Bingham went on at 7 to identify the object of Section 127 (1)(a). The object of Section 127 (1)(a) and its predecessor sections is not to protect people against receipt of unsolicited messages which they may find seriously objectionable. That object is addressed in Section 1 of the Malicious Communications Act, 1988, which does not require that messages shall to be prescribed, have been sent by post, or telephone, or public electronic communications network. The purpose of the legislation which culminates in Section 127 (1)(a) was to prohibit the use of a service provided and funded by the public for the benefit of the public for the transmission of communications which contravene the basic standards of our society. A letter dropped through the letterbox may be grossly offensive, obscene, indecent or menacing, and may well be covered by Section 1 of the 1988 Act, but it does not fall within the legislation now under consideration.
17. Those observations are not directly in point, but in my judgment the wording, legislative history,
and context make it apparent that the mischief at which the offense now contained in section 127(2)(c) was aimed is not the communication of information or ideas that offend the recipient, or even the communication of messages that have offense as a purpose. Its object was to prohibit the abuse of the facilities afforded by a publicly funded network by repeatedly exploiting those facilities to communicate with another for no other purpose than to annoy them, or cause them inconvenience, or needless anxiety. The focus is not on the content of any communication, but rather its purpose and the way in which that purpose is put into effect. I have no doubt that repeated instances of prank calls, silent calls, heavy breathing, and other common forms of nuisance phone call, containing no meaningful content would fall within the scope of section 127(2)(c). I do not mean to suggest these examples are exhaustive, but they do indicate the kinds of behavior that I consider the legislature intended to prohibit by enacting this offense. I am not persuaded that content will always be irrelevant, but I see much force in Ms. Wilson's submission that what Parliament intended was to prescribe a course of persistent conduct the sole purpose of which is to cause annoyance, anxiety or inconvenience by virtue of its persistence,
rather than its informational content. 18. The approach is well known.
A measure that interferes with freedom of expression is only justified if it is prescribed by law, pursues one or more of the legitimate aims identified in Article 10(2),
and is shown convincingly to be necessary in a democratic society. Necessary is not synonymous with indispensable, but nor is it as flexible as such terms as useful, reasonable, or desirable.
One must consider whether the interference complained of 1 corresponds to a pressing social need, 2 is proportionate to the legitimate aim pursued, and 3 is supported by reasons which are relevant and sufficient. The authorities are cited in Connolly at 19:23-27. Some of the consequences of this approach are spelled out in the harassment authorities I have cited. But the points made in those authorities are not confined to cases of harassment. They apply to that crime and tort because, and to the extent that, it engages the right to freedom of expression, and applies to a course of conduct. The same general principles must apply in the present context. 19. It is against this background that the prosecution and the district judge should have approached this case.
It is evident that neither did so.
Had this case been approached by the judge in a legally correct manner, it should have been dismissed. 20. This appeal illustrates the need for decision makers in the criminal justice system to have regard, in cases where they arise, to issues of freedom of speech. In that context, I add by way of footnote that when reading the judgment of Nicklin J. in Hayden v. Dickinson, which Warby J. has cited, I was surprised to read at paragraph 39 that the defendant, who like Ms. Scotter had been arrested following a complaint made by Ms. Hayden, was released on pre-charge bail. One condition of which was that she was not to post on social media anything relating to the claimant, emphasis added. It will have to be decided in some other case whether a condition of this kind can be justified under Article 10 or S.3.6 of the Bail Act 1976. Note 1. A magistrate's court shall not try an information, unless the information was laid, within 6 months from the time when the offense was committed. For these reasons and those given in the judgment of Warby J., with which I agree, I too would allow the appeal and quash the conviction.